Greetings and welcome to Quo Warranto, Checklist and Forms from American Jurisprudence. All right, we're going to have Black's Law Dictionary 9th edition at our side to make sure we leave no word behind. And with that said, let's get right down to it. So as we get people to file in here, please hit the like so that word gets out about this kind of information so that we're more empowered to deal with our government and the people there that are utilizing the authority with the trust of the people. Let's get started. The governing principles. The right to institute Quo Warranto proceedings resides in the state unless delegated by statute to individuals. Generally, it is the duty of the state attorney general, district attorney, or other proper law officer to bring these actions. A private person may not do so except where the proper officer refuses to proceed or consent to the filing of an information or complaint, or unless the private person is granted the right by statute. And more information in this in the 65 AmJur 2nd edition on Quo Warranto. And that's in sections 60 through 65, so leave word in the chat if we want to make that a future presentation. Generally, leave of court to institute a Quo Warranto proceeding is not required where it is instituted by the proper officer without being on relation of a private person. If the proceeding is instituted by the proper officer, by or on relation of a private person, then leave must be obtained from the court in the absence of a statute to the contrary. So check your state statutes if there's a statute that provides the private person from instituting a Quo Warranto proceeding. But that power is normally given to the states. The states can give it by statute to the private person. Leave to institute Quo Warranto proceedings is sought by petition or other appropriate application, which must be verified if the statute so requires. In some jurisdictions, the application is presented to the state's attorney for signature and is addressed to the court having jurisdiction in the matter. In other jurisdictions, the application is instituted by the state attorney general on behalf of the state on motion for a rule on the defendant to show cause why leave should not be granted to file an information in the nature of a Quo Warranto against the defendant. In most jurisdictions, the grant or denial of leave to institute proceedings rests with the court passing on the application. In some jurisdictions, a private person in the position of relator is required to give satisfactory security to indemnify the state against the costs and expenses of the proceeding. Interesting there. So here's a first checklist we have here. In preparing a petition or application for leave to institute Quo Warranto proceedings, the attorney should consider the following. But before we consider this, I want everyone to consider the fact that this is only an entertainment educational broadcast, not to be used for professional, personal, business, or legal use. Don't do this at home. And before we go any further, I'm not sure if everyone is familiar with what the writ of Quo Warranto is about. I thought they would have a definition, but we don't have definition here. So before we go any further, it would behoove us to go to Black's Law and quickly look through here and get to Quo Warranto as a definition in Black's Law to help us out. For those that don't know a good definition, and I'd rather not paraphrase before we go any further. And while this is catching up, I'll catch up with the chat. We have Yum in the house. Greetings, Yum. Good to see you here. And anyone else? Let's see here. Just pipe up in the chat with any of the questions or any clarifications, any digressions, and I'll be happy to accommodate. And this is a scanned version of Black's Law, so it does take time to find the word, but we will. Yeah, it's catching up here. Once it gets up here, it'll start moving a little faster. There we go. We're on the J's. Was there murder of the first degree, murder of the second degree? It's good words here. The nice thing about flipping through the pages of a real book is you get to have this serendipitous occasions here of glancing on interesting words or words you may have not known in depth, or words you didn't even know. All right, we're getting there. The P's, we could just scroll on here until we get to the Q's. Actually, let's do a couple more jumps here. Oops. Yeah, I knew there was going to be only a few Q's here. It's going to be a shaky one to jump into here. All right, here we go. Quasi. A lot of quasis here. Quasi-estoppel, quasi-tort, quasi-tenant. Interesting. All right, and here we're narrowing it down here to Quo Warranto. Goodness. Did I pass it? There it is. All right, Quo Warranto. Let's see the pronunciation. Did I get it right? Quo Warranto. All right, also Quo Warranto. Quo Warranto. Well, I'm doing the first one here for tonight's presentation. It's from Law Latin. By what authority? From the 15th century. A common law writ used to inquire into the authority by which a public office is held or a franchise is claimed. Also termed writ of Quo Warranto. Cases in action by which the state seeks to revoke a corporation's charter. The federal rules of civil procedure are applicable to proceedings for Quo Warranto to the extent that the practice in such proceedings is not set forth in statutes of the United States and has therefore conformed to the practice in civil actions. Let's continue here. And we have a nice little illustration here. There are two modes of proceeding judicially to ascertain and enforce the forfeiture of a charter or default or abuse of power. So what we're really focusing on here was the abuse of power aspects of it. The one is by something fascious, and that process is proper where there is a legal existing body. Scire fascius, or fascius, and that process is proper where there is a legal existing body capable of acting, but who have abused their power. So this is one process that's proper where there is a legal existing body capable of acting, but who have abused power. The other mode is by information in the nature of a Quo Warranto, which is in form a criminal and is in its nature a civil remedy. So it's a criminal in form, civil in nature. And it's a remedy that the proceeding applies where there is a body corporate de facto only, but who take upon themselves to act, though for some defect in their constitution, they cannot legally exercise their powers. But these modes of proceedings are at the instance of and on behalf of the government. The state must be a party to the prosecution, for the judgment is that the parties be ousted and the franchises seized into the hands of the government. Let's see here. So there's a lot of complexities to here, so let's continue. Quo warranto means by what warrant or authority, and was a proceeding to inquire whether authority existed to justify or authorize certain acts of a public character or interest. Originally, the proceeding of Quo Warranto was a criminal one instituted by the Crown, the purpose of which was to find out in the course of a formal inquiry whether or not persons or corporations were exercising a privilege or franchise illegally, going against the Crown. Yeah. Or if persons who had no right to do so were occupying some public office. If it were found that the person or corporation was in fact illegally interfering with the prerogative power of the Crown, or was in fact doing some other illegal act, it was ousted from the illegal practice or office. Accordingly, it can be seen at once that the proceeding on Quo Warranto was not one to be used by private parties in the conduct of ordinary litigation. So, now that we see the history of the Quo Warranto was to remove usually someone working for the Crown, corporation, or individual, and way to weed them out because they were kind of going against the prerogative of power. And because of that, it's not something to be taken from private parties. It's not the private party's power that was being usurped by the corporation or the other one in that criminal act, illegally acting, exercising their privilege or power. It would be the state or the Crown to do that. Now, I guess in America, in American government, you'd have the aspect of the people's trust. So I guess some states would give the authority to the people to initiate the case. However, it still is an act of the state to do because it's historically would be an act of the Crown. Interesting. All right. Well, enough of that digression. Let's get back to our checklist. And within the checklist, in preparing a petition or application for leave to institute Quo Warranto proceedings, the attorney should consider the following: whether application is necessary or whether a direct right of action is conferred by statute. So whether you can do a direct action because your state allows it by statute or whether an application is necessary. Proper court in which to present application. That would be where you're not doing the direct action. Whether local statutes or procedural rules require that application be presented to and signed by the proper official. So you would have to go to that official outside of the court. Disclosure of probable grounds in application. Whether supporting affidavits are required. Whether notice of application must be given to defendant. That would be according to your statute. And of course, your request or prayer for relief. And of course, verification. If the application is made by a private person after refusal of the proper official to do so, this fact should appear in the application. So, interesting, we have a nice little checklist here. Only 8 points to do. Unless there's a refusal, you would also have that fact in here too. Now we go to section 89, allegations as to office or franchise. If the information is regarded as a complaint or accusation against the defendant for usurpation of an office or franchise, its chief characteristics are an accusation of an usurpation and a demand that the defendant show the authority for his claim. So then the defendant is going to have to show the authority. It is merely necessary to set forth in general terms the office, franchises, or privileges alleged to be usurped. The Attorney General is not required to show in the information the special grounds he relies on. Show in the information the special grounds he relies on. If the state so chooses, it may allege generally that the person holding the office or enjoying the franchise in question does so without lawful authority. And in such case, it devolves upon the defendant to show a legal right to enjoy the privilege in question. So it devolves upon the defendant to show a legal right to enjoy the privilege in question. So that's what this writ is doing. It's enforcing these requirements for the franchise or the office holder. If the state does not avail itself of the right to allege usurpations generally, it may set forth the specific facts in a manner similar to that required of a private person who files the information in assertion of his claim to office. Where the proceedings are for the purpose of trying title to public office, specifically from the allegations that the office exists, if the office is a local one created by ordinance. So must specifically in the allegations that the office exists. You see these kinds of wording says, yes, this is an office that exists as part of this apparatus or public body, and it is indeed, created by the ordinance, such and such and such, code number, blah, 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 blah. So it is otherwise where the office is one created by a general or public law. General or public law, since the existence of such latter office will be judicially noticed. Where the proceeding is instituted by a private relator claiming the office. Oh wow, the pleading should contain averments showing a title or right in him. However, some statutes have been held not to make it incumbent on the relator to put his own title into the office in issue, though the defendant may do so by challenging it in his plea. The defendant's possession and use of the office, wow, possession of office, without right, should be alleged, and it is not sufficient to assert a mere claim on his part to the right to exercise the office or franchise. An information which alleges a state of facts which prima facie support the title of the defendant to the office in question must likewise allege the facts relied upon to rebut presumption in favor of the defendant. So key contained in this, your allegations must likewise allege facts relied upon to rebut the presumption in favor of the defendant. So you got to be ready to break down the presumptions in your original allegations, is what they're saying here. Otherwise, it will be insufficient to support the proceeding. So important procedural thing here. Where the act complained of is the holding by the defendant of incompatible offices, the possibility that the act is within an exception recognized by law must be expressly negatived. Wow. The possibility that the act is within an exception recognized by law must be expressly negatived. So this is interesting here. The act complained of is a holding by the defendant of incompatible offices. The possibility that the act is within an exception recognized by law must be expressly negatived. That's an interesting phrase. So what we're saying here, if you're complaining that a defendant is holding two offices that are incompatible, the possibility of that act of holding those two incompatible offices within an exception recognized by law, meaning that there's no law that makes an exception for holding those incompatible offices, that must be expressly negative, that you have to expressly say there is no exception to law that would allow these incompatible offices. So this is so thorough the way you're looking at a bulletproof way to make your allegations. Number one, if you're making a state alleging facts, the rebuttals to those facts in favor of the defendant must be made in those original allegations. Otherwise, it would be insufficient to support the proceeding. And also, when when the act was complaining about the holding of incompatible offices, that possibility, if it was an exception by law, must be expressly negative, meaning that you have to expressly show that it's not an exception recognized by law, that they are therefore incompatible offices, not just prima facie, but in law. It has been held that an information against persons intruding into corporate offices must show that the corporation exists, and therefore, if it is not created by special charter of which the court can take judicial notice, it must show the manner in which the organization became a body corporate. And the nature and duties of the officers should be described to show whether they are offices within the meaning of the law relating to the usurpation of franchises. Wow, interesting stuff here, and that gets in a little bit more into the structural aspects. Excuse me. And this one has a heavy focus on Florida too here, a lot of these cases. And here are footnotes. You can take a look here, and here's some notes here. The effect of thus alleging the specific facts is to advance the pleadings one step, and is the method that the legislature evidently intended to be used, where the Attorney General files the information upon the relation of a party claiming title to an office. So if you say, that's my office, you would go to the Attorney General and relate that to him, and he or she, and they would take action from there, allegedly. An averment that the office was created or attempted to be created does not make the petition demurrable on the ground that it seeks to remove respondent from a non-existent office. Whew, a lot of negatives there. So an averment that the office was created or attempted to be created does not make the petition demurrable. Wow, on the ground it seeks. Okay, so you have another one here with an information is insufficient in this respect, which alleges merely that the relator appears by the returns to have a majority of all the votes without alleging that he actually had such a majority. Appears to by the returns without alleging that he actually had. Wow, so the wording is very careful here. You have to allege that you actually have the majority of votes, I guess, if you're going to complain about the vote count. All right. And another footnote, holding that a bare averment in the organization is a corporation created by the authority of the state is insufficient as a mere conclusion of law. Okay, and if the defendant or respondent wishes to meet charges made against him and set up matters in bar, he should do so by return, plea, or answer according to the practice in the particular jurisdiction. If the defendant fails to set up his defenses by appropriate pleading, he may not be able thereafter to avail himself of them. So, case authorities here too. 1 second here. Gotta check up on the chat too. All right, we got some chat here. 1 second here. Yeah, I think we the people have a political authority, so we could use that. Indeed. Now, the history of the Quo Warranto and why we were kind of focusing on this is that it's actually one that was originally done by the Crown. Right to receive a privilege which can be taken. Remember, these are office holders, so everything is something that's through the trust. All right, clear this out here. All right, let's continue on here. All right, back to, oops, there we go. All right, so we were saying here, let's see, okay, return plea or answer supplement. Case authorities in Quo Warranto action. Respondent adequately responded to complaint. when he filed a motion to dismiss, which was denied, and thereafter timely filed his answer because, even though RC section, whichever that is, provides that the defendant in a quo warranto action may either demur or answer, the rules of civil procedure also apply, and respondents pleading complied with their, civil procedure rules. And here we go, another one. Let's see, just some cases there. Okay, where a plea is the proper pleading and an answer is filed, it may be treated as a special plea if not objected to. Okay. So a proper pleading would be a special plea. Where no claim of invasion of constitutional right is set up by the respondent in his answer, he cannot avail himself of such a claim thereafter. Plea or answer after demur has been overruled. See Section 95. All right, now we're on to Section 92. Form and sufficiency. The defendant's pleading in quo warranto should possess the requisite certainty and precision of the allegation, and not be inconsistent or repugnant, evasive, or argumentative, or constitute negatives pregnant. Where necessary, it should conclude with a verification, which we saw in our checklist. That was the last thing, was a verification. The pleading should be responsive to the information or complaint so that material issues may be formed, and should not attempt to take issue on matter which does not constitute a statement of fact. It must, therefore, admit or traverse the usurpation and disclaim or justify title, right, or authority in or to the thing the respondent is charged to have usurped. If the respondent admits to the usurpation or disclaims title, prosecution is entitled to judgment. But if he traverses the usurpation and justifies his title, he may have his rights determined by a trial. The plea of not guilty is not a sufficient answer, since it amounts simply to a traverse of the allegation of usurpation, and fails to respond to the demand of the information that the defendant show his title, right, or authority, as we saw in the introduction. This is true whether the action is brought by the Attorney General or behalf of the public or by a private relator. This is not sufficient for the defendant merely to deny the relator's title or to state generally that the defendant has a legal title or right to the office or franchise in question, or that he was appointed or elected to the office. He must allege facts showing on the face of the pleading that he has a valid title to the office or franchise. As against the state, when the information contains a general allegation that the person holding the office or exercising the franchise does so without legal authority, the respondent may meet this by setting up in its answer as justification an act of the legislature authorizing the exercise of such franchise. So an act of the legislature could be their source of authority, apparently. Where the office in question is a corporate office filled by an election of the stockholders, the plea should set forth that the election was held agreeably to law and in conformity with and in pursuance of the ordinances and regulations of the governing board of the corporation, and that at such election the defendant received a majority of the legal votes cast. If his claim is by virtue of an election by the board of directors to supply a vacancy therein, he must show the existence of a board competent to elect, and that a vacancy existed therein, how such vacancy arose, and his subsequent election. So you see this little part of another checklist here, right? This is, of course, the boards of directors, but believe me, a lot of the public bodies are actually corporate. If the plea shows an election by electors acting under color of legal right, it is sufficient that the electors were not possessed of the proper qualifications must be pleaded in avoidance by the state. In pleading his own eligibility, it has been held that on the question of citizenship, the mere averment of the fact is sufficient. But where the question is the ownership of land or stock, the existence of the ownership must be shown specifically and necessary title papers exhibited. That's interesting here too with the Quo Warranto. An answer to a complaint charging defendants with usurping the rights of a corporation which specifically denies that they or any of them have unlawfully claimed or unlawfully exercised such franchises has been held sufficient without affirmatively justifying the right to exercise such franchise. Although the existence of the corporation is affirmatively alleged, since the latter allegation may be treated as mere surplusage. Interesting there too, surplusage. Oh gosh, that's footnote 38. Let's jump to that real quick, see how they come up with such a word. Nothing special on that one. All right, let's look at these footnotes here real quick and see if they have any further details we could glean from this. Otherwise, the cases are here if you do want to do follow-up. And let me check on the chat here really quick. Be free. Greetings to you. All right, so on the footnotes here we have the practice aids, the answers and defenses in Quo Warranto under the pleading and practice forms. And of course, if anyone is further interested in this, I could do more details on some of these, the 65 AmJur and the pleading and practice forms too. An accusation of usurpation is the information is a statement of fact. So the accusation is a statement of fact, and the defendant may take issue thereon by plea. The demand that the defendant show authority for his claim is not a statement of fact. So the demand's not, it's the accusation of usurpation. And the defendant should not attempt to take issue thereon by plea. So the demand to show authority for claim is not a statement of fact and should not attempt to take issue with it by plea. But the accusation they can. The demand, however, showing that they have authority for their office, position, exercise of franchise, etc., should not be answered with a plea. A plea, partly of justification and partly of disclaimer, which is neither a complete plea of justification nor a full disclaimer, is bad. Good comment there. I think it adds into what we just read. Where title to an elective public office is involved, a plea is sufficient which alleges that the election was held, that there was authority to hold it, and that the defendant received the required number of votes. Alleges that, okay, the answer of a municipal corporation to an information in the nature of a Quo Warranto, filed in the name of the state on the relation of the Attorney General, to test the right of the respondent to exercise the powers and franchises of a municipal corporation over certain specified lands, should be full and specific to show just exactly what the city had done or failed to do or planned to do with respect to furnishing municipal benefits to the described territory. It's interesting. That's in Davis versus Stewart, Florida. A few of these, and this was in 97. And we're on to evidence and proof. Section 103, generally. The rules of evidence generally applicable in other civil actions prevail in Quo Warranto. Presumptions as rules of evidence may be invoked even against the state as readily in such proceedings as in ordinary civil actions. Thus, it will be presumed that a court that permitted an information in the nature of quo warranto to be filed did so on proper grounds. Even where a statutory action has been substituted both for the common law prerogative writ and for the information in the nature of quo warranto, the substance of what constitutes the basis of quo warranto relief remains the same. In order to prevail, proof of the substantive elements authorizing such relief should be of the same kind, quality, and quantity as would have warranted a favorable judgment under the older form. There are footnotes for that burden of proof. In ordinary civil actions, the burden of proof generally rests upon the plaintiff to prove his title or right to the thing in controversy. But in quo warranto, in the absence of any legislation or controlling consideration to the contrary, remember, if there's a legislative act that says they should have that authority, the burden of proof may rest upon the respondent or defendant. So, in the case of a quo warranto, the defendant actually has a burden of proof. The burden of justifying acts of usurpation rests upon the respondent at all times. Although, as stated in the following section, a prima facie showing of right to the office in question may cast the burden on the relator. So remember, there's always, you got to have the rebuttals to that prima facie showing of the right of office right off the bat, because that would cast the burden on the relator now. In some jurisdictions, however, the rule obtains that the burden of proof in a quo warranto proceeding or an action in the nature thereof is to be determined from the issues raised by the pleadings precisely as in other actions. The first stated and generally accepted rule is based upon the character of the proceeding. By the ancient writ of quo warranto, the respondent was called upon to answer by what right he held the office or franchise under dispute. He was compelled to show his title, and if he failed to do so, judgment was entered against him. The same rule was applied also in cases where proceedings by information in the nature of quo warranto were resorted to as a substitute for the writ. So the information in the nature of a quo warranto were resorted to as a substitute for the writ. And, in general, this rule, notwithstanding statutory changes in the form of procedure, still remains as the peculiar feature of these proceedings. Nice. So, in quo warranto, against one practicing law without a license, where it is shown that the respondent was engaged in the practice of law, the burden of showing due authority by license devolves upon the respondent. Oh, wow, in Alabama. So this is an interesting one to pay attention to. Franchise. All right, now we're on to Section 111, the statutory provisions. Let's take a quick glance at the chat and see if there's anyone here still tagging along here. I appreciate everyone that's sticking with me through this. This is important information that's rarely touched upon. As you can already see, there's some special distinctive features about the quo warranto that usually aren't talked about but are much needed in our legal system. The matter of jury trial in quo warranto proceedings has been set at rest in England by the passage of the Act of Parliament of 3 George II, Chapter 25, which specifically provides for a jury trial in such proceedings. All right, so it's been settled. In some of the states of this country, also, the matter has been placed beyond the necessity of discussion by explicit statutory provision that quo warranto proceedings are triable before a jury. Quo warranto proceedings, being special and extraordinary proceedings, do not fall within the purview of a statutory provision restricting the right of trial by jury to actions denominated actions at law. So, well settled. Nothing worth talking about here, as they quite say here, is beyond the necessity of discussion. All right, in the statutory action that in some states is a substitute for quo warranto proceedings or proceedings in the nature of quo warranto, the constitutional guarantee of a jury trial does not require a jury in such action where, at the time of the adoption of the Constitution, the right to a jury in such proceedings did not exist. Wow, so Idaho is where that state ruling was, depending on the time the Constitution exists as ex post facto, huh? All right, ouster or seizure of franchises. Woohoo, section 116. Under the ancient Quo Warranto, judgment against a corporation was the franchise be seized into the king's hands. Is that seized? Yeah, seized into the king's hands. But under the information in the nature of Quo Warranto, a fine was imposed, and ouster decreed, without forfeiture of the franchise. So that's under the ancient Quo Warranto. The judgment was that the franchise be seized in the king's hand, but under the information, the nature of Quo Warranto, a fine was imposed and ouster decreed without forfeiting the franchise. The character of the judgment in Quo Warranto proceedings involving corporations or associations or persons, assuming to act as a corporation, depends somewhat on whether the proceedings are aimed at the usurpation of a corporate franchise or at acts constituting forfeiture by non-user, misuser, or surrender. Okay. The judgment to be rendered is different in the two different modes of the proceeding. If the information has for its object to test the right of the respondents to act as a corporation, and to oust them from doing so, it is filed against the individuals. And the judgment in favor of the state is one of ouster against such individuals for unlawfully assuming to be a corporation. But if the object is to effect the dissolution of a corporation that has had a legal existence, or to oust such corporation from a franchise illegally exercised by it, then the information is directed against the corporation, and the judgment for the state is against the corporation, ousting it of the franchise and seizing the same into the hands of the state, or, in other words, of ouster and dissolution. In the event that a special franchise other than that of being a corporation is usurped or abused, the judgment may oust the respondent corporation or individuals from the exercise of such franchise, or for the privilege of being a corporation. Where the corporation conducts its business in disregard of the laws of the state, or has failed in the discharge of its duties by uniting with others in carrying out an agreement, the performance of which is detrimental or injurious to the public, it thereby offends against the law of its creation, and consequently forfeits its right to exercise its franchise any longer, and may be subject to a judgment of ouster. The judgment may go to the extent of declaring a forfeiture of the defendant's corporate franchise, or the court may render a judgment of forfeiture or ouster only of the defendant's right to carry out the illegal agreement. A special franchise, where wrongly exercised by a corporation, may be forfeited without dissolving the corporation or depriving it of its general franchise to be a corporation. In such case, the judgment may also be suspensive of judgment of ouster with a fine accompaniment. Oh, what a nice accompaniment. Or may be a simple fine, if it appears that the illegal practice complained of has been abandoned. So, depending on the situation, it looks like the difference in the penalty. But before we go further, I think we should get a little bit closer to the legal definition they're using here of franchise. Because we see here there's a special franchise they're talking about here in a general franchise. So, once again, it behooves us to look into Black's Law here, and let's look up franchise as it applies here in Black's Law. And let's get to the F's. One of these days I'll get one that scans a little bit easier here, or scrolls easier. All right, let's see where we are here. All right, we're on the G's. We'll just scroll on up from here because it'll come quick. The end of the F's here. Yeah, a lot of FUs. Here we go. Fruit and tree doctrine is a nice one. Fruit of the poisonous tree doctrine. The rule that evidence derived from an illegal search, arrest, or interrogation is inadmissible because the evidence, the fruit, was tainted by the illegality, the poisonous tree. Almost there. Free of charge. Good freedom. Where's here? When you get to franchise. All right. Lots of fraud too. All right, here we go. We're getting close. I can feel it. There we go. Franchise. 14th century, to grant to another the sole right of engaging in a certain business or in a business using a particular trademark in a certain area. That's that franchise. Now I see some other franchise. Special franchise and general franchise. Okay, so here we go. Here's another franchise. Oh, hang on a second. Okay, here we go. Starting here, franchise. The right to vote, also termed elective franchise. 2. The government conferred right to engage in a specific business or to exercise corporate powers. Government conferred right is a franchise. Also termed corporate franchise or general franchise. All right, so see, we are getting some detail here with franchise. When referring to government grants other than patents, trademarks, and copyrights, the term franchise is often used to connote more substantial rights, whereas the term license connotes lesser rights. Thus, the rights necessary for public utility companies to carry on their operations are generally designated as franchise rights. On the other hand, the rights to construct or to repair, the rights to practice certain professions, and the rights to use or to operate automobiles are generally referred to as licenses operate. In a violent conceptual collision, some franchisors maintain that a franchise is merely an embellished license and therefore revocable at will. Franchises contend that a franchise is a license coupled with an interest, not subject to unlimited control by franchisors. As a result of this disagreement, legislative draftsmen have had difficulty defining franchise, so that's why we're looking it up. Franchise appurtenant to land, rare. All right, so general franchise, a corporation's charter, so we saw that word. And then special franchise, the other one we're looking up. A right conferred by the government. So a general franchise is a corporation's charter. A special franchise is a right conferred by the government, especially one given to a public utility to use property for a public use, but for private profit. Interesting here. Sole right. Okay, so business, commercial franchise. So I think we got it pretty well there. That's what we were looking for. General and special franchise. General franchise in this context for the Quo Warranto is a corporation's charter, and the special franchise is the right conferred by the government, especially when given to a public utility. All right, and we're back. Get back here to that. All right, there we go. So a special franchise conferred by government, right, where wrongly exercised by a corporation, may be forfeited without dissolving the corporation or depriving it of its corporate charter, its general franchise, to be a corporation. Now that makes a lot more sense, doesn't it? That one sentence there, by just looking up legal definitions of a word, special franchise and general franchise. It's changed it quite a bit, and now it makes a lot more sense in this sentence, because if it's just a right conferred by the government to the corporation and they abuse it, then they forfeit that right, but they do not lose the corporation. If, however, the general corporation, the charter is the general franchise. In such case, judgment may also be a suspensive judgment of ouster with a fine accompaniment. So if they want to really nail them, they'll give them a fine with it, or just a fine if it appears that the illegal practice complained of has been abandoned. Nice. All right. Well, Captain Jack, you're going to have a baby? It's not that late yet. That's after 3 a.m. We're still on the East Coast here. Can't do that here. All right. Good to see you here, though, regardless. An abuse of a corporate franchise does not occasion a forfeiture of the corporation's lands or goods, rights, or credits, or in fact a forfeiture of anything other than the franchise itself. So a judgment of seizure of the corporate franchises for violation of its charter cannot direct a seizure of the corporation's possessions. So I think now it should be clear to everyone why in law that the possessions of the corporation aren't seized in the action of the Quo Warranto. However, a judgment of Quo Warranto would lead towards further actions which perhaps could lead to seizure of possessions. But that's just my opinion. All right, so we have here relief in Quo Warranto does not include the declaring of the act done to be null and void, but it extends only to a firm or a judge as unauthorized the franchise or power which may have been, with or without color of right, unlawfully exercised. Whew. A law is of doubtful constitutionality that provides for a forfeiture of all franchises for a misuse or abuse of a franchise, because it offends against the provision that all penalties shall be proportioned to the nature of the offense. Okay, so there it is. That's why the property is not seized for the action. Misuse, abuse. Where a railroad holds a right-of-way that it has forfeited by failure to operate its road within 10 years of the grant, the judgment in favor of the state in Quo Warranto to test the company's right to hold the right-of-way should merely oust the defendant railroad from the right-of-way. So they never owned the land? They just had the right-of-way. Now they don't have the right-of-way. In Quo Warranto against a natural gas company to forfeit its rights as a corporation and for such other relief as may be just and proper, the court may, in the exercise of its discretion, upon proof that the defendant entered into an agreement with a competing company fixing the price of gas to be charged to consumers, rendered a judgment declaring forfeiture of the defendant's corporate franchise, or it may render a judgment of forfeiture or ouster only of the defendant's right to carry out the illegal agreement. Jeez. I think they deserve a nice little accompanying fine, too. Where a combination of fixed prices was charged against a defendant in Quo Warranto proceedings to oust it from a franchise to do business in the state, the court said that under all circumstances a judgment of absolute ouster was not necessary, and that the ends of justice would be satisfied by the imposition of a fine and the payment of costs, with an alternative judgment of ouster if it failed to pay the fine and costs. Oh, how nice. damages, and salary. Well, I think on tonight we're going to leave it on this. We've gone over the hour mark here. I like to try to keep it digestible for everybody and make it enjoyable to learn these. If you guys want to know more about Quo Warranto, I have a lot more on Quo Warranto, and we have still more checklists and forms to go through. But we've gone through some of the essence of it here, and let's check in with the chat and see what else we have here. Well, Captain Jack, I think you got some better business to do here that we're not going to be revoking the franchise anytime soon. So have at that. Try and get that cleared out there. And if there's anyone else has anything to say here in the chat, we got Audit Them in the house. Greetings to you. If anyone has checked out his channel, you got to check out at Audit Them and see some great governmental audits there. Plenty of good candidates for Quo Warranto through his videos if you see that. So if you want to test any of these checklists and forms, processes and procedures, lots of great candidates that are displayed there awaiting your nomination on Audit Them's channel. But on that one, I would like to thank again everyone for showing up here tonight. I hope to see you all on the next one. Make sure you hit the bell notification so you get alerted, because sometimes we get a pretty bad, let's see here. We got some more comments coming through here. We have Andrew Robert. Greetings to you as well. And we have, let's see here. Chat's not refreshing here. Give me a moment here to refresh it. Oh, Lord. There we go. Now I see everyone's stuff there. Yeah, sometimes you want to be judged. Not here. This is a no judgment zone. Yeah, your brain would probably melt after it much longer. Well, put it this way. Salute to all you that have made it this long, because most of the esquires that you might have to go up in contention against don't have this much of an attention span. So you've already been able to show a little bit more wherewithal. On that note, I would like to thank you all for showing up here tonight. I know there's a lot more exciting and dramatic things to be seen on the YouTubes, but this really shows, you know, a good showing of people that care about what we have here in this country to express it and to make sure that it's being done in the people's interest. Salute to you all, and I'll see you all on the next one. Peace out.